Hey guys, welcome back to the channel. Today we are discussing an important topic for business owners and companies. Deciding whether to borrow internally from shareholders or to take out a loan from a bank. Let's break down the legal issues and financial considerations involved. First, let's look at borrowing from shareholders. This is known as internal borrowing. It's often seen as a quick and flexible way to raise funds, but there are some important legal issues to consider. Number one, shareholder agreements. Ensure that your shareholder agreement allows for internal loans. It is quite common for shareholder agreements to specify an order of priority if the company needs to borrow money. For example, the clause could state that if the company needs to borrow money, these are the following options in order of priority. For example, the clause could state that if the company needs to borrow money, these are the following options in order of priority. Shareholders' loans first, the issuance of new shares, and lastly, borrowing from external lenders or banks, and so on. It is also important to have a separate standalone loan agreement between the shareholders and the company, which should outline the terms and conditions of the loan clearly in order to avoid future disputes. The most important point is the interest rate, which should be reasonable and comparable to market rates to avoid any claims of unfair treatment or tax issues. But in practice, if a company has to borrow money from shareholders, it usually means that the company is in trouble, so it usually is an interest-free loan. Another important clause to include in the loan agreement would be the repayment terms of the loan, whether in installments or in one lump sum at maturity date. Finally, ensure that any decision to borrow internally from shareholders is approved by the board of directors and documented in meeting minutes to maintain transparency and accountability. Next, let's discuss borrowing from banks and financial institutions. While this option might involve more formalities, it comes with its own set of advantages and legal considerations. First, banks will provide detailed loan agreements, usually called facility agreements. It is crucial to review these documents carefully, possibly with lawyers, to understand all the terms and conditions. The second consideration is interest rates. Banks typically offer competitive interest rates, but they can vary based on the company's creditworthiness and market conditions. Always compare offers from different banks. You should also note that when you borrow from banks, there is usually a clause in the facility agreement that deals with default interest rates, which means that if you don't pay back any installment on time, you will have to pay default interest in addition to the normal interest that you have to pay. The third consideration when borrowing from banks and financial institutions is collateral. Many bank loans require collateral. Fourth consideration, covenants and obligations. Bank facility agreements sometimes come up to more than 100 pages, often come with covenants, which are conditions that the borrower must comply with. This can include maintaining certain financial ratios or restrictions on additional borrowing. Carefully review the default clauses in the loan agreement. Know what constitutes a default and the bank's remedies, which could include demanding immediate repayment of the loan or seizing collateral. So how do you decide which option is better for your business? Here are some key points to consider. Number one, flexibility. Internal borrowing from shareholders can be more flexible but may strain relationships with shareholders. Second point to consider, costs. Compare the total costs involved, including interest rates and fees. Internal loans from shareholders might have lower upfront costs, but ensure they are in line with market rates. Third consideration, approval process. Bank loans involve more rigorous approval processes, but they may also provide structured repayment plans and potential additional resources. Number four, consider the risks associated with each option. Internal borrowing from shareholders can create internal conflicts, while bank loans put company assets at risk. At the end of the day, the best choice depends on your company's specific circumstances and financial health. Always consult with legal and financial advisors to make an informed decision, and always get a lawyer to review your loan or facility agreement before signing it. In my career, I have seen too many business people who blindly sign bank facility agreements without consulting with lawyers and only realize that they're in hot soup later on when they do not repay the installments in time. Thanks for watching. Don't forget to like, share and subscribe, and I'll see you in the next video.